as usual, I'm joined by and supported by my colleague Adrien de Hauteclocque from the court, and also, of course, attached to the Florence School of Regulation. So today we would like to take you through quite a number of cases. Adrien will kick off on two very high-profile cases, and then I will take up the baton to look at some other important cases, and then we will have a quick resume of what is pending before the court. So what we'll be coming back to in future webinars. So I'd like then to hand over now to Adrien to take us through a very important case concerning the institutions and a very important gas competition case concerning a well-known Russian gas company. Thank you very much, Adrien.
Thank you very much, Leigh. Hello, everyone. Happy to be here with you for an hour and a half, talking about all the cases we have adopted lately and some of the pending cases. So we have many cases. So in the interest of time, we will not cover everything because it would be great to have a little bit of discussion. On my side, I will cover indeed the Meckel case, so a regulatory case concerning Acer, and the case concerning the Gazprom saga, which started about 10 years ago. So I'll share my screen. I hope this works. So I will wear more my academic FSR hat this time, so that, of course, I'm talking only in my private capacity. So let's start. So yeah, so the Meckel case, which is a very recent case, and I know it's been the source of discussions, in particular among the national regulatory authority, and I think from an EU standpoint, it's quite original, it's interesting. So let's have a look. So in terms of the background, we are talking about the upgrade of the infrastructure between Hungary and Austria. The idea there was to bring some gas from the Black Sea in order to increase, of course, energy independence. So the project was sponsored by the two TSOs on both sides. And what was interesting is that when the market tested demand, the result was very different on both sides. The Austrian side was very enthusiastic, and the Hungarian side a little less. So the two TSOs went to the two regulators, and unsurprisingly, E-Control, so the Austrian regulator, approved the case, and MEC rejected it. So pursuant to the dispositions of the Acer regulation, there was no coordinated decision by the national regulators, and so Acer became competent to decide on the proposal and accepted the incremental capacity, incremental capacity project on 9 April 2019 on the basis of Chapter 5 of the CAM gas network code. So this is the provisions in the network code where you have the dispositions and the articles concerning incremental capacity projects. There was an appeal by the regulator and the TSO before the Board of Appeal. That appeal was dismissed by the board, and of course then there was an appeal to the General Court. So let's see what the General Court said. So first, it declared inadmissible the appeal as insofar it concerned the initial Acer decision, so the one of the agency and not the one of the board. So the argument was simply that if you have the opportunity to go before the board, you have to go, and you cannot go before the General Court right away. So this was inadmissible as concerned the initial decision. But then still, it annulled, the General Court annulled the decision of the Board of Appeal, and this is what we need to discuss. So MEC raised what we call a plea of illegality. So in a plea of illegality, you said that a decision of an institution or an organization of the union is illegal because the legal basis on which it was adopted was itself unlawful. So in the context of a plea of illegality, if the court upholds the argument, it doesn't conclude that the legal basis is illegal, but that it's inapplicable to the parties to the case. So there's no erga omnes effect. So it only applies to the in the context of that particular dispute. And in that case, the decision of Acer was adopted on the basis of Chapter 5 of the GAM Network Code. And the argument was that the network code is a delegated act, which means that it's adopted by the Commission on the basis of another act, and this other act was the gas regulation. And according to the court, the Commission was not empowered by the gas regulation to adopt that part, that Chapter 5 of the CAM network code, and so then declared inapplicable that part of the network code, and then the decision illegal. So that's, of course, fairly rare. We don't have that many of these pleas of illegalities, and of course, they raise questions. So here, of course, the main question is why it was declared illegal. It was declared illegal simply because when the Commission adopts a delegated act, it has to the purpose of a delegated act is to amend the main act, but only on non-essential elements. And there the question was, of course, is it an essential element? What is an essential element according to pursuant to the case law? According to the case law, it is an essential elements are those which, in order to be adopted, require political choices falling within the responsibilities of the EU legislature. So the co-legislature, and of course, here it certainly is the case in the sense that Acer was applying Chapter 5 in the capacity to impose an investment on the national regulators, and according to the court, this was not possible. And it's true that when you look, so the reasoning was, I think, mainly on two grounds. Is the fact that all the provisions in EU energy law that are about investments in the networks, they are in the directive and not in the regulation. And it's clear that in the directive, it is the member states who have to ensure compliance with the obligations on the part of the NRAs, and not Acer. So that was really much framed as a competence case. It's really, there was no competence for Acer, for the Commission to adopt that part of the network code, and for Acer to force regulatory authorities to give the green light to the investment in the network. There was also another argument, it was around the fact that in the legislative procedure leading to the adoption of these legislations, there was an amendment proposed by the European Parliament, and which was rejected by the Council, which aimed to give to the EU level that kind of power, and this was rejected. So it was really much framed as a competence case. The case does not say anything about the procedure itself. So the Chapter 5 and the incremental capacity process, there's nothing wrong in itself with that process, but there's a problem of competence. So then the question, there's no erga omnes effect. So the judgment as we say res judicata only for the parties to the case. So then the ball is on the side of Acer and its Board of Appeal, and on the Commission to implement the judgment under as it's said, of course, in Article 266. So now we will see what the ACER and its board are doing, what the Commission is doing. So of course I hear, and I think they are legitimate questions about the inapplicability of the Chapter 5 on existing running projects, because of course now I think for future projects, I mean, you can't base them on the Chapter 5 of CAM network code, of course. That would be yeah, very risky. But then on running project, I can understand it casts some doubt, even though the whole rationale of the plea of illegality is that it's only applicable to the parties to the case. So also for the future network code, if we have, what is essential? We have the case law, the Dyson case, I think, which defines fairly clearly, at least, what is an essential element, and this has to be taken into account. So I'll stop there on that case, Leigh, and move on to the Gazprom case, which is the competition case I want to discuss, or the competition cases, because there are two cases. So maybe a bit of background. So it's been 10 years. We have been in this, even more, I think, because I think the Commission started to investigate the fact a little bit before 12. So I think somewhere in 2010 or 2011, but in any way opened formally the administrative procedure in August 2012. So we've heard a lot, of course, over the years on that case. I think so why do we have two procedures? Is that there is what we call the main proceeding. So the Commission investigated, sent what we call a statement of objections to Gazprom in 2015. This led to what we call a commitment decision. So where the Commission doesn't say that there is an infringement of the competition rules, Article 101, Article 102, but still adopt commitment negotiated with the company. And this commitment, of course, addressed the competition concerns that are raised in the statement of objections. 2 years after, a bit more, yeah, exactly, almost exactly 2 years after the statement of objections was sent to Gazprom, the main, or maybe the only, I don't even know, the wholesaler in Poland, which I will call PGN, introduced a complaint against Gazprom. And of course, the allegations were, of course, similar with what was in the statement of objections, but it was wider in some parts and some of the parts were missing. So we had two procedures that way. So the Commission adopted the contested decision in May 2018 and rejected the complaints on two grounds in April 2019. So there were some procedural hurdles because the Commission, in a sense, absorbed some part of the complaints within the main proceedings. So some of the arguments raised by PGN in its complaint were tackled by the Commission in the main proceedings, which is an issue, of course, in terms of procedures. And then it rejected the complaints of PGN on two grounds. I can say very quickly, PGN was focusing his complaint on some behaviors of Gazprom around the management of the Yamal pipeline. So the Yamal pipeline comes from Russia through Belarus to Poland and Germany, and Gazprom was a shareholder of the owner of the infrastructure, Europol, and through that shareholding was able to abuse maybe its dominant positions and implement some anti-competitive behaviors in Poland. And the complaint was rejected by the Commission, in particular saying that there was no interest. It was not in the interest of the Union to pursue a specific case, because there was also the main case. And the second argument was that there might have been some issues around the application of the state compulsion doctrine. And so I'll come back to that in a moment, saying that if there is no margin of maneuver for the company because it's owned by a state, then it's not acting as a private company, so as a private undertaking, and so then the competition rules would not maybe apply. So judgment on the 2nd of February 2022, two judgments, one for the main proceeding, one for the complaint, and one in the main proceeding is appealed before the Court of Justice. So just as a reminder, I mean, it's very familiar because we've been hearing about that case for 10 years, but very quickly, there was an issue about unfair high prices in the long-term contracts Gazprom was signing with the wholesalers in the different member states. These long-term contracts were linked to oil prices, and so of course there were discrepancy. So at least when the Commission adopted the decision between this and the wholesale prices in Western Europe, which were much more competitive, and so there were some sort of differences between the two. There were also some territorial restrictions, so some limitations in the way the buyers of gas could resell the gas, and there were different ways Gazprom was segmenting the different markets so that it could keep its market power and prevent completion of the internal market. So there were a lot of commitments and several pages, of course, of commitments. In the end, the idea was first to get rid of the restrictions on the flows, on the cross-border flows, of course, giving some more leeway to the wholesalers to resell and to reship or to change the delivery points of gas. So it's all about, of course, completing the internal market, and also the fact that the prices should reflect more the benchmark, some benchmark reference prices in the West. So, well, I think it's there are fair cases, interesting, not so fairly technical in some ways, but not so much. One is very long. It's 150 pages judgment. The result is that there was the appeal in the main proceeding was rejected, and the decision on the complaint was annulled. On the procedural part, I think what is interesting to keep from the judgment is that it's fine not to have commitments for every competition concerns highlighted in the statement of objections. It's true that, especially concerning Yamal, the Commission had expressed some concerns, and there's nothing in the commitment decision, which can appear surprising, but still, it's doable as long as the Commission states reasons why it did that. So there was no problem, but explains why the competition concerns highlighted are not addressed by the commitments. The court confirmed that there was no problem with handling part of the request, part of the complaint in the context of the main proceedings, as long as you have the same rights of defense. So the one who introduces the complaint had to enjoy the same rights of defense in the context of the main proceedings. That was not completely the case in that Gazprom case. But when you look, you also see that the complaint was introduced very late in the process, 2 years after the statement of objections. So, well, it was some procedural modeling from the Commission, but that was not so easy, I think, to handle. I've heard in the different commentaries that the second judgment was often interpreted as a problem, as a problem on the part of the Commission of not stating reasons why it didn't why it took the decision it took. It's not the case. If you reread the judgment, it's not a problem of a duty to state reason. The main problem was that the PGN was not able to give a position on the use of the state compulsion doctrine because it was not clear before the contested decision that that would be the argument used. There were some hints, but at no point PGN was able to reply on what was in the end the arguments used. Just to finish it up on that case, a bit on the substance, it's interesting to see that it was not treated in the same way, the arguments concerning Yamal in both decisions. The main point is that there was so Gazprom was a shareholder of the owner of Europol, so the owner of the grid, but there was an ISO and the independent system operator, which was certified under the sectoral legislation by the national regulators. And so, as you have that certification, what's the impact on that in the context of a competition assessment? And that was a bit different in the two cases, and the reasons is that the allegations made were stronger and wider in the complaint. In the main proceeding, the court said that the fact that there's no commitment is fine. So there were some competition concerns in the statement of objections. However, there was that decision of certification, so that was enough not to impose other commitments. And this is without prejudice for the national authorities to find an infringement of 101 and 102. However, in the complaints, it was different. The court found that there was a manifest error on the part of the Commission not to pursue with the case, which could be considered a bit contradictory with what it said in the main proceedings. However, I think the main difference here is that the allegations were way wider in the complaint than in the statement of objections. Then very quickly, three last points on the issue of the pricing. The court said that the Commission strategy, so not to redraft all the clauses, to introduce revision clauses with a reference to benchmark competitive prices and the reference to arbitration and the monitoring of commitments was enough. There is an interesting bit for arbitration aficionados. So we are in. So there, the idea was that you can go to commercial arbitration. In commercial arbitration, in the case law, according to the case law, there's no general obligation to apply all elements of EU law. However, that's fine because we know that in the context of an annulment proceeding of the arbitration award, the national judge has to apply 101 and 102 as a public policy ground. So still there is some application of the competition rules. And here the innovation is that it's clearly said that the commitment decision is part. Applying 101 and 102 means also applying the commitment decision, because the commitment decision is adopted on the basis of Regulation 1, which was adopted on the basis of 105. So we are in a legal seminar. So, of course, Article 105 is how the Commission is empowered to implement rules to apply 101 and 102. Last point was a link with Article 194, because there was the argument that basically the Commission blocked everything and that there was no room for the national authorities and to regulate in different ways the behavior of Gazprom and everything. And this was rejected by the court, saying that the commitment decision is really addressing the competition concerns, that it encroach on the competence of the member states to implement energy policy and their competence under Article 194. I'll stop there and hand over to Leigh.
Thank you very much, Adrien. Thank you very much for taking us through that huge Gazprom commitment, 150 pages decision in a whirlwind fashion. Before I go on to my cases, maybe there was just one question that we could take just now from Thomas in the chat. And he asks, in relation, of course, to the first case, about the definition of political choice. So when, when should an act actually not be delegated to the Commission because political trade-offs are involved?
In my understanding, not in that particular case. No, I agree. This is not very, very clear. I mean, it's an issue we know for a long time. Even the issue of what's the difference between a delegated act and an implementing act has been clarified over the years, and in particular following Lisbon. So I guess we have to come back to the Dyson case and try to apply that case law. But yeah, I mean, it's still probably a little bit fuzzy.
Thank you, indeed. I think there was the old Schengen case as well, where there was some discussion about what was political and what was not. Whereas I think in this case it was much more technical and economic, right? In the case that you just discussed today.
Yeah, indeed. I think there in that case there was no doubt. I mean, you framed the case as a competence case and really looked at it in that way in the context of a plea of illegality. I think the fact that it's a necessary element is fairly clear. There's no, it's limitedly mentioned in the gas regulation. In which area the Commission can adopt a network code, and it's hard to fit investment in that box, I think.
Yeah, indeed. Thank you very much. I'm sure this will be a case that it might well be appealed. We don't know yet. It'll be interesting to see what happens. And as you said, it creates quite a bit of uncertainty for existing projects. So I would like to move on. I have quite a number of cases on my list. I won't cover them all in great detail. We advertised a long list of new cases, but we only have a limited amount of time to go into them all. So we sort of picked out some of the interesting ones. And one of the very interesting ones for regulated utilities is the case SEN, Servizio Elettrico Nazionale, that was handed down just very recently. And if I could have the next slide, please. The facts of this case are not dissimilar to what has happened in many countries where you've had integrated monopolies, in this case Enel, in Italy, of course, who had responsibility for everything, and then with unbundling. Adrien just mentioned the unbundling rules in the context of the Gazprom case. But here, of course, what was at stake was that Enel no longer had a sort of direct route to the final consumer because a new company, SEN, had been entrusted with the customers that were in what was essentially the liberalized part of the market. Now, liberalization, of course, has happened in stages, and Enel had served these very customers itself up until a certain point in time, and then they were transferred to SEN, which was actually a subsidiary of Enel. The problem here really was, well, how to manage data on customers between the old monopoly, Enel, and the new entity, SEN. And this we call the problem of data leveraging. Now, it's quite a complicated case because we're not talking about a refusal to supply type of case, which is often the way we deal with access to infrastructure, physical infrastructure. It's more that SEN's decisions to give information about customers could have been discriminatory, because they might have been giving priority or preference to ANEL, to EE. So it's important to keep that in mind. This is not a refusal to supply case, which we often, of course, look at the behavior of monopolies or former monopolies in that sense. And we are very concerned about access to physical infrastructure from the refusal to supply perspective, because if you don't get access to infrastructure, of course, you don't have access to consumers downstream. Now, that issue, of course, has been taken care of by regulation in the energy market. But the issue of data, who can have what data, is not clearly regulated in any of the packages for electricity or gas. And that's why we have to resort to competition law. And it's important also for competition law purposes that here, in fact, because this is a parent and subsidiary relationship, the courts start from the premise that these companies are actually one and the same undertaking within the meaning of Article 102, and that has implications for liability for sanctions, who has to pay fines. So turning to the next slide, please, Max. What this judgment is important for is what's known as the replicability test. And the Advocate General's opinion, which is a very long opinion and is like a textbook of how to apply the competition rules, he spent quite a bit of time to try to describe how important this test could be, because a monopoly is still allowed, of course, to compete. Being a monopoly isn't a problem under competition law. It's the way you use your monopoly powers. And if you use those monopoly powers to compete on the merits, as we call it in competition law, then there's nothing wrong, because everyone has to compete. But the problem is, how do we draw a line between competing on the merits and actually abusing a dominant position? Now, there's a lot of literature about this. There's a big discussion about whether we should have a difference in how we interpret abuse of monopoly power when we're dealing with pricing issues, like margin squeezes and offering rebates, or non-pricing issues like refusal to supply. But the basic idea behind the replicability case is, well, can this data be replicated? Data being then the customer base, can that be easily replicated by an equally efficient competitor? And if that is the case, then one could say there is competition on the merits. But another theme, another thread in competition law is, of course, that if you have had a super dominant position, or you have a super dominant position, then you have special sort of responsibility in the way you behave on the market. And that has to be taken into account because, of course, Enel was the incumbent monopolist. It was bringing a lot of advantages, as it were, to the table. And so it had to be seen through that lens. It has this unique position, had these unique assets, which had not been obtained at the time on the merits, on the basis of competition, but because the company had had exclusive rights granted to it by the state for so many years. So it was very important that this former monopoly, this incumbent company, had this very strict duty not to impair the competitive process. So that was a very important point of departure for the court in its analysis. More emphasis on that, I think, than in the Advocate General's opinion. So moving on to the next slide. Why is this important? Well, this is one of the first cases at EU level, at least, on data leverage in the energy market. We have had some national cases, but this is the first EU level case. And it raises then issues about non-price related competition, so competition because you have data as an asset. And it highlights how important and sensitive data and its use, access to it, of course, is in the market liberalization process. So data is obviously a very competitive tool, and if you have access to formerly captive customers, then once the market is opened up, then this is critical then for the development of competition. So this is an important case. There's a lot of commentary already on it. This last slide just summarizes the court's findings, which I put there just for ease of reference. But given the time, I'd like to move on now to the next case, which is a Romanian case, Fondul Proprietatea, I think it is. This is actually a case concerning two electricity generating companies, and these two companies have also generated quite a bit of case law. This is the last or the most recent, and the Romanian government, I think, has spent many hours, or maybe even more than hours, but tried to find many ways to prop these two electricity companies up. At the moment, the most recent way of trying to maintain these two companies, which I don't think have been ever very competitive, was to give them sort of guaranteed access to the electricity grid on the basis that this was necessary for security of supply. Obviously, this is a case that predates the current emergency situations. But what the Advocate General concluded when looking at this case, which came from the Romanian Supreme Court, I believe, he looked at whether or not the right of a guaranteed access to the grid for these companies to discharge security of supply type obligations could be seen as a service of general economic interest. And if that was the case, then the courts could apply the exemption. However, the National Court had also asked questions about state aid rules and to what extent these two companies, which are also partly owned by the state, could benefit from this priority access or guaranteed access to the electricity grid, because it would seem that it wasn't clear, at least, that they were paying the normal tariffs, so that by being given guaranteed access, they were also being given a form of state subsidy, a state aid. And the court asked for clarification then on this point. And if we move to the next slide, you'll see that the court looks then at what the TSO is doing and what functions the TSO has. It comes to the conclusion then that if these two companies are not paying the full price for access to the grid and to ancillary services to Transelectrica, and Transelectrica is the TSO, which is also a public undertaking, then this puts a financial burden on state resources. The state is the majority owner, and therefore it's losing money if two of the biggest electricity users, network users, are not paying for their share of the grid use and the ancillary services provided by the TSO. So moving on, that was an important point because there's definitely state resources involved here. And the court then relies on the recent Achema case, the Lithuanian Gas Case, which we've talked about in past events, to find that all the conditions of Article 107 are in fact met. And this means that strictly speaking, before any payments are made, or before any guaranteed access is given, the issue should have been notified. This legislation should have been notified to the Commission for clearance, and it seemed that that had not happened, and that the standstill requirement, of course, had not been observed. And we know that only the Commission can grant an exemption. The national courts cannot grant an exemption from the state aid rules on the basis of 107, paragraph 3C. However, the national court could apply Article 15.4 of the directive. So it could apply the right to priority access or guaranteed access. But they would still have to have the state aid clearance. So this is a fairly complicated outcome, I think, for the National Court, because it seems they would first have to get the payment for this right in the form of a state aid to be cleared before they could apply Article 15.4 of the directive. So an important outcome, I think, especially as we'll probably have quite a few cases about guaranteed access in the future. Priority dispatching, of course, has that idea of having precedence that was given to renewable electricity. That has, of course, disappeared in the fourth package of the electricity legislation. But guaranteed access for security of supply reasons is still possible. So moving on then to our next case, this concerns the gas market. This is a Latvian case. Again, it's a case coming from the Latvian courts, the Supreme Court of Latvia, to the Court of Justice on the interpretation of a directive. And we've had a similar case about the interpretation of what is meant by access and what is meant by connection to a grid network in the electricity sector some years ago. That was case 23907. But what's important here is, of course, these principles are now applied to the gas market, but the Latvian gas company, I've shortened it to LG, it in effect wanted a right of first refusal. It wanted to be able to say to a very large network user, a major industrial company, that it would have to connect to its distribution grid. And it could not request being connected to another part of the grid. So this was the way this Latvian gas company, which of course had also had to be unbundled and operate as a separate transmission company, a separate distribution company. They wanted, of course, to make sure that they didn't lose customers. Now, this legislation in Latvia, which actually gave a right to certain users to connect to the transmission grid if they wished, was challenged as being contrary to European law by Latvian Gas. And noticeably, the Regulatory Commission in Latvia had also looked at the issue and said, well, you know, Article 23 of the directive, which in fact, these are the rules on the ITOs in VIUs, in vertically integrated companies. So you're still allowed to have an ITO that owns different bits of the company, but you're subject, of course, to very strict regulation. But the question then is, you know, does that regulation, Article 23, does it also require special conditions on connection? So that was the key question. Now, going on to the next slide, please, Max. The court really recalls that earlier judgment on the electricity sector and repeats what it found at the time, that the relevant provisions of the directive, Article 32 on the right of third-party access, is only concerned with access and not connection. and the same rules must apply to gas because the wording is essentially the same. So the provision cannot be interpreted as laying down an obligation on member states to actually include any right for a final customer to connect to its national gas network. So it's very important then to keep access and connection to be are separate, and third-party access does not extend to connection. So moving on then to the next slide. Here, what's maybe also interesting is that there were several questions, 4 questions were put to the court. I haven't been able to go into all of them, but of course, one of the questions before the court, and this was the Grand Chamber, was to what extent do member states still have a choice as to how they adopt national legislation dealing with matters that are not covered completely by a directive. And here the court says, well, the directives must be interpreted as not precluding legislation of a member state where the transmission of natural gas includes the transmission of natural gas directly to the natural gas supply system of a final customer. So it was, in fact, up to the member state then to choose how it wanted to regulate where the final customers could connect to the system. So that's an important case because access and connection then are kept as separate concepts. So moving on then to our next case, and these are all, I'm afraid, cases that are not easy to pronounce, and I will attempt it, Vysočina Wind. And this case, I will not spend too much time on, but it's an interesting case because it's about the retroactive or retrospective application of a directive. In this case, a directive that has been adopted in the interests of improving circularity, so the reuse of materials and the proper management of waste, which applies to PV panels in this particular case. Now, it's a rather, again, a complicated background, which I can't go into in great detail here because we haven't got that much time. And I'm just checking my Mickey Mouse watch here. So I don't want to take all our time up. I'd like to leave some time for questions. But what's interesting about this case is that the court held that the principle of legal certainty precluded the retroactive application of the directive. So what had happened was that the directive of 2019 would result in the shift of who paid what for the management of these waste costs. And eventually, according to the directive, that would be placed on producers. But what had happened, because of the wording of the directive was unclear, in fact, producers were made to pay for managing these costs in a period that predated the entry into force of the directive. So in fact, in the period from August 2005 to August 2012. However, to make matters more complicated, the national law that was adopted in anticipation of the directive had already shifted these costs. That then had to be looked at in the light of the new directive. And what the court says, well, if you're just anticipating the entry into force of the new directive, that's actually what you're meant to do as a member state. So even if these producers had to pay these costs, and even if it was invalid for them to do so, they couldn't claim damages because this was not a sufficiently serious breach of European law. So that's a case which illustrates that you might win the battle, but you don't win the war. So maybe you won on the point of principle, but economically you were not better off. Turning then to the next case, which is also, I think, a similar case where you thought you won the battle, but it turns out you don't win the war. And this is a case coming out of what is usually referred to as the Dieselgate scandal. And it actually also raises some of the issues that Adrien talked about at the beginning in the Hungarian case about to what extent delegated measures, delegated acts are allowed to deviate from their parent acts, and to what extent then the Commission can change testing values when this hasn't been fully anticipated by the basic legislation. Now, the General Court upheld, in fact, complaints by various large cities in Europe that the Commission had changed these driving emission standards in a way that was not compatible with its competencies under the relevant directives. And so it had imposed a standard that was actually not strict enough. However, these cities were confronted with having to allow dirtier cars then because the standard was not strict enough. And so they appealed then, challenging the Commission's competence to do this. They won before the General Court, but the Commission, supported by 2 member states, challenged that judgment before the Court of Justice. Now, it's a very interesting case for many reasons, or the history is very interesting, because it raises them, first of all, procedural questions. What about standing? So to what extent do these cities, regional entities, have the same type of standing as a member state itself when a member state wants to challenge a European act? Or are these cities to be treated like you and me, and we have to show then that we are directly concerned if we want to challenge a regulatory act adopted by the Commission? And the second issue that came up was, as I was just saying, what is the Commission's room for manoeuvre? How much choice does it have if it's amending a non-essential element of the basic act, the basic instrument, when it's trying to do this through implementing legislation? So a very important case. But if we move on to the next slide, please. The court takes a fairly strict attitude and says, well, these cities, they're not like member states, so they have to meet the full test, that they must show that they are directly concerned. And so they have to show first that they are directly affected, their legal situation is directly affected by the measure in question. And second, there must be no discretion left to the addressee who has the task of implementing it. And this is now fairly standard European law. When you want to challenge a regulatory act, you have to meet these two tests, so direct concern and no delegation of power. And if we move on again, we see that the court found that the General Court had not applied those tests correctly. When it comes to the second case, the second part of the case, the scope of the Commission's manoeuvre to change the Euro 6 testing facility, the court found that it didn't have to go into that because, of course, there was no standing in the first place. So these 3 cities could not have challenged the substantive exercise of the Commission's competence. Now, it's interesting because Advocate General Bobek had actually followed the lower court and found that the 3 cities should have had standing, but he thought that the Commission could have changed the legislation. So that was not an essential element. So an interesting case, even if for many reasons, even if the court dismissed it on more formalistic grounds. And again, I think we'll see a lot of challenges coming through to delegated instruments. Just think of all the taxonomy cases. These are all, of course, cast as delegated legislation, secondary acts, and there's going to be a lot of litigation as to what the Commission can and cannot do in delegated legislation. The additionality regulation, for example, under the RES directive is another case in point, and we will have, as we've been told in Repower EU, we'll have also some delegated instruments defining what is low carbon gas and low carbon hydrogen. All of this will be put in delegated acts, and I'm sure a lot of this will be challenged. Okay, moving on. Another case which is interesting when it comes to legal protection when things change, and of course things are changing a lot in the energy world at the moment, is Millis, the Italian PV tariff reduction case. Now, this is an interesting case because it's one of many cases in many member states where, having been given very generous feed-in tariffs, solar energy producers or PV energy producers have found themselves faced with a fairly severe tariff reduction some 5 or 10 years into the lifetime of their investment. And this happens in Italy, as it did, of course, most notably in Spain, which with a lot of litigation has emerged, Greece, Germany. There are many countries, the Czech Republic, where tariffs have been reduced. And the courts then have been called to judge whether this was fair play on the part of the state authorities. Now, in the Italian case, in fact, in 2015, the incentive tariff for energy produced by PV installations was quite drastically reduced, and the operators of existing facilities were given various options as to how to rejig their tariffs, depending partly on the period to which the tariff was still to be paid and the amount of energy that the installations were producing. So there were basically 3 choices for how much the tariff then would be reduced. And if you didn't communicate the choice you wanted, then the authority responsible for processing the tariffs would choose the last one, so the 8%. So that would be what you would get. So it was obviously much less than many companies had been used to. And Millis then decided to fight this, this decree of the Italian legislature. So going on to the next slide, this resulted then eventually in a ruling before the Constitutional Court of Italy that the relevant decree law was not unconstitutional, and that the interests at stake had been balanced fairly. So the state had made a fair trade-off between the general interest aimed at reconciling the support for the production of renewable energy with a reduction in the burden of the costs for final users. Obviously, the costs had been going down, and so it was fair to reduce then the feed-in tariff to reduce the level of subsidy. So also the Supreme Court, the Constitutional Court, held that a prudent operator could have seen this coming, that no prudent operator would have assumed that they would have had 24 or 25 years of an uninterrupted level of support. In the Italian system then, the case goes back to the national court. The national courts then, when they try to apply the guidance that they've got from their own constitutional court, still are faced with certain uncertainties, and they refer some questions to the Court of Justice. So moving on then to the next slide. In fact, it was the Administrative Court of Lazio who then brings up quite a bit of concern about the principles of legal certainty and the protection of legitimate expectations, because there has, of course, been support provided for renewables under several renewable electricity directives adopted by the EU. So the question really was, to what extent, having relied on the directives, the company Millis could also invoke wider European constitutional rights, in particular Articles 16 and 17 of the Charter of Human Rights, and interestingly, Article 10 of the Energy Charter. Now, those of you who perhaps follow energy law, European energy law, know that the Energy Charter is not entirely the most popular instrument at the Court of Justice for various reasons. But Article 10 does provide a protection of investment rights. So the court then, in this case, the European Court, was asked to have a look at these general rights protected by the Charter: freedom of enterprise, right of property, the right then to enjoy uninterrupted support, allegedly flowing from Article 3 of the RES Directive of 2009, as it then was, and the Energy Charter. So quite a nice menu of rights was served up in this case. Now, moving then to the next slide, we see that the court was rather indifferent to these arguments. It looked, for example, at the directive on renewable energy, and recalled that it was really up to the member states to decide what they wanted to support in terms of forms or sources of renewable energy. And they also had a great deal of discretion as to how they designed their support schemes, if they chose to give support, because, as paragraph 30 of the case reminds us, there's no obligation provided in the directive that member states must provide support for renewable energy in the first place. They could do it in many ways. At the time, of course, under that old directive, member states did have binding national targets to meet to ensure the famous 20% target, but they had considerable discretion as how they would do that. With, for example, as we saw in the Romanian case, priority access to the grid was one of the types of ways they could do that under that version of the directive. So moving on then, the directive didn't help. The Charter doesn't help either, Article 17, because this doesn't give any sort of complete right. Again, it's a right that has to be balanced with wider principles and the wider issues then of the rights of the state then to protect its own budgetary interests. And again, it's argued that the prudent economic operator could not expect that things would remain unchanged for the entire duration of the agreements that had been entered into with the Italian agency at the time. So modifications then were not in breach of Article 17 of the Charter. So the decree law did not breach the Charter. And finally, we come to the Energy Charter. So if we move to the last slide, then poor old Millis didn't have much success relying on that argument either, because although the court recognizes that the charter is binding on the EU, its Article 10, though, provides that each contracting party, and Italy was at the time a contracting party. It has, of course, since withdrawn from the Energy Charter, but at the time it was a contracting party, and it provides then Article 10 that the contracting parties must create favorable and transparent conditions for investment, etc., but for investors from other contracting parties. And Millis was an Italian company, Millis SPA, so it didn't merit protection under Article 10 because it was not an inward investor. Again, poor Millis then had to, I think, just accept that it was going to have a reduced tariff for its supply of PV electricity in the Italian system. So that then, I think, concludes my share of the case law, my short commentary. As I said at the beginning, we couldn't cover all the cases that have come before the court in the last 6 months. Unfortunately, I couldn't cover all the state aid cases. So I hope, though, that we'll have a chance to revert to them on another occasion. But I think what you've seen today from Adrien and I is that there's really a lot of important cases coming down that will have a very important impact on the energy transition and the changing rights of different parties in the system. So we do have question time now, and please let me know. I think you can, it's easiest if you put your questions in the Q&A box or in the chat box. Maybe while we're waiting for people to digest all this material, Adrien, we could, in the interest of time, have a look at the pending cases. You're on mute, Adrien.
Yeah, sure. I mean, that would be nice to address some questions. But yeah, it's true what you said. I mean, there are so many cases, and we have not been able to cover everything. But we see there are more and more cases. These sessions that we do for already some years, and they are heavier and heavier for sure. And in all the cases you discussed, I think the NL case, the first one, very, very important. There's a bit for everybody. I think in that case, it's interesting in different ways. Also, of course, for the regulated sectors, in particular energy, but also from a wider point of view, because we have all the cases concerning the platforms and everything, and of course, this NL case also has some relevance. I think something also is the Ville de Paris case. When I'm listening to you, I mean, it's a very interesting case, but in the end, I mean, the question of standing, we've been discussing for years. It's an issue. I mean, it's a bit of a pity that these cities, have not been required standing. So the pending cases, it's always, I'll share my screen again. Is it done? Yeah.
Yes. Yep.
So it's always it's a bit of a difficult exercise always, because there are so many cases pending at different stage of their lives. It's difficult also to have an idea of which one will really proceed until the end and which ones are important or not. Sometimes it's a bit difficult. So I'll give you a snapshot of what I could find. I'm sorry if I'm missing some big cases we'll be discussing in the next session. So on competition, this time it's a bit small. We have one which is Bulgarian energy holding. This very interesting case, fairly technical though, but very interesting, concerning access to the network and that kind of issue. I think very interesting case to follow. We will discuss it definitely next time, or the one after, depending when it comes out. We are in the middle of reviewing the merger or the different asset swaps and buyout in the context of E.ON and RWE relationships. We have several groups of cases, so it's quite a number now. So this one is a big one. So we will have to see what comes out. On the regulatory side, I could spot two. Swiss grid is a bit different. It's the question of the involvement of the Swiss TSO in the European platform. So that's a bit specific. Green networks seems to be a bit more traditional, about consumer protection and the power of the national regulatory authorities. It looks interesting. We have a big one, the opinion 120, the question coming from Belgium, and it's again, we just discussed it a bit in the context of the Gazprom case, the issue of the link between EU law and arbitration, and in particular with the Energy Charter Treaty. So this one is probably an important one. Then we still have a few cases, less than before, concerning the capacity remuneration mechanisms of the different member states. We had discussed last time the cases concerning the UK, and I think this one, in a way, pretty much closed the door, or at least set the framework. So we have these two cases. One thing that is really booming is the stream of cases concerning Acer, so to which belong, and the first case, the Maker case we discussed earlier. So I tried to list the case, but at some point I stopped. There were so many cases, so I'm not sure that list is complete. So of course, and we have of course the case at the general court level, but then they get appealed. So of course, it's an issue. It's an issue. All these cases, we've specialized one chamber of 5 judges at the general court to deal with these cases. But yeah, I mean, it's complicated. So sometimes very interesting because we discussed one this time, but all the past sessions we've been discussing one specific case concerning Acer. So all these cases raising really interesting issues. We always have a few anti-dumping cases these days concerning always solar. I mean, this is imports from China, in particular, imports of biodiesel. We have a few cases. We always have a few ETS cases. I mean, that's so the case is referred by national courts, for example, concerning the granting of free allocations. They are fairly technical, but still interesting, and we have an ongoing flux of cases concerning the ETS, or even the taxation of energy products. Just to finish it up, the stated cases, always a lot of them, of course. So now we have the appeals of some of the cases we discussed in earlier sessions. The Copestro case concerning exemptions from network charges to electro-intensive users in Germany. There's an appeal. The one always is the special case concerning preferential tariffs in Greece. Irish wind farmers, we mentioned last time, is being appealed. There is 2 preliminary rulings, which looks interesting. I could spot the one, Vijam, ESPO. There is, it's about the incentive effect in the guidelines. There has been, we had the conclusions of the Advocate General on Rontos, him again, on the 2nd of June. So yesterday, so we will probably be discussing that case next time. I could spot one on rest support scheme in Latvia. In the area of annulment proceedings, we have, I think, one we need to follow concerning the cogeneration support schemes in Germany. Germany itself is in the we have to follow also the Hungarian case concerning nuclear. It's it's a bit of a follow-up to the Hinkley Point case, but still a few independent issues, and so the hearing was probably 2 to 3 months back, so we could expect the judgment this year. And then support schemes to the coal phase out in the Netherlands. This one seems interesting, and one to biogas in Sweden also I could spot, and that's it. But among the dozens of cases I could find, I mean, it's always difficult to make a choice, and that's it.
Thank you, Adrien. Thank you very much.
Up.
We do have some. Thank you. I think, as you can see, we will have plenty of material for our follow-up seminar in the autumn, and maybe even some seminars in between.
We have Leigh?
Yes.
We have a question on the NL case.
Exactly. I was just going to turn. We have still 10 minutes, so we have a few questions in the chat. So indeed, we have a question on the NL case. And there's also a question about whether or not the recording will be available. Yes, we will post a summary of the session with a link to the recording on the website. So on the NL case, the question is then, how does it relate to Google Shopping? I think I saw the question. Well, I think what you see here, maybe Adrien might want to comment. The Advocate General produced a very long and detailed, almost textbook opinion on this case. But it was very odd in a way that he didn't refer to Google Shopping, and the court doesn't actually refer to it either directly. But I think there is much more emphasis in the court's ruling on these special duties of super dominant companies, which can make it more difficult, I think, to know when you can compete on the merits. For these large companies, they have to be extremely careful in what they do with data, for example, in this case. So that, I think, is why a lot of people say, well, when you look at this issue of is it replicable or not, that's really only half the story, and you have to look to see what to what extent these companies are really able to benefit from assets that they didn't acquire under normal competition. Adrien, do you want to comment on that, or?
Yes and no, because that's I think that's a very true. I think the opinion of the Advocate General was an excellent opinion in quality, but still, I mean, up for debate, really, I think. And in that case, you have many different issues. I mean, that can be discussed. The substance, I mean, of the special responsibility. I mean, I'm not sure this is that wide when you look at the judgment. It discusses also, I think, an interesting thing, for example, which is what is normal competition, and this is in the end now fairly clearer what it is in a context, for example, of the energy transition. But what it is in other contexts, it's not so sure. And in the end, you can read. It's a bit what I said last time in the beginning. I mean, you have a bit for everybody in that case. And if you transpose that case in the context of the platforms and Google shopping type of cases, I don't know if it's that restrictive to what these big incumbents can do. So big companies can do. So I mean, really, I mean, super interesting. There is also a question concerning in the chat concerning the personal data angle. Leigh, I don't know if you can answer that question. I mean, personal data.
Yeah, they are, and they would be protected. They would, of course, be protected indeed. But I suppose one of the issues there were the links between the firms and whether that would have allowed some sort of transfer. I'm not sure. It's not my area of expertise, but I think what we always say as regulatory lawyers, it doesn't matter what system of regulation applies or what exemptions or what rules. The treaty competition rules are treaty rules, and they take precedence over detailed legislation at secondary level. I think what will be important for people in the sector is to see what kind of guidance the Italian courts will then give, because they, of course, have to now give a final ruling on whether or not there was data leveraging. And I thought, I mean, the Advocate General, his opinion was very long and very detailed, but it didn't really give much practical guidance for the court.
It's very academic.
Yeah.
Very academic.
Yeah.
It's also interesting to see that you have parallel cases at national level, and as you mentioned it actually earlier, and it's true that when you look in France, you have that case from I think end of March this year, where the French competition authorities fined EDF for the same behavior for 300 million. So which could have been, when you read the judgment, which could have been way higher. So it would be interesting to see if we have other cases at national level.
Yeah, and we have one more question here from Angus Johnson. It's always nice to hear from Angus.
Yeah.
He would like to know about the Millis approach and whether it's consistent with ECTHR positions on the first protocol. Indeed, I think I'm trying to read your I didn't get into the first protocol. It was discussed, wasn't it, in the Millis case, and it certainly it seems to have been dismissed as, again, it was recognized, if I recall, that it was a protected right, but as the rights are not absolute, then it was sort of dismissed as being applicable. I'm not an expert on the first protocol, but in the cases that I've seen, it's very difficult to make a case stick there. So it's true, the contracts were possessions, they were property, that's recognized in the Millis case, but that didn't sort of give you any blanket coverage. I'm not sure whether it was different in the UK cases, whether or not there was that these rights were upheld in any way. But first protocol rights are usually recognized as being rights, in my sort of limited knowledge, but not absolute rights. So most courts recognize that member states or contracting parties should have the right to change their law. That's what it comes down to, basically, unless there are very special interests at stake. Let me see if there's another question.
There's another one concerning NL and Google Shopping. Well, it's hard to answer that particular question, but what is important is the is the efficiencies than the dominant operators can put forward to justify, and it's very present in the case, I think.
Yeah.
So
the equally efficient operator test, you mean?
yeah, it's at two levels. You're not abusing your dominant position if an equally efficient operator, blah blah blah. So at that level, and then even if it's abusive, then you can still justify your behavior if what you would do would raise efficiencies, and this could come from innovation for the consumer. So, and this, of course, that type of things seems a lot more relevant in the context of Google than in the context of NL. And that's why, I mean, you see that there's a wider context in this kind of judgments.
And you could argue, and I mean, it's in the final dispositive part of the judgment that, of course, they could justify restrictions if indeed they could show that the consumers were achieving efficiency. But it is quite important in the energy sector if you're going to, offer customers demand response services and all these kind of add-ons. I mean, often people say the last thing that an energy company sells is energy these days. So, there's many reasons why you might want that customer data, and you might well be able to offer customers a lot of services that your rivals would find difficult to do so as efficiently. So it is, as you say, it's a complicated test at the second, especially at the second level, I think. It's a justification. If are you really passing the benefits on?
The problem is that the facts of these cases, both NL and the French case, which I know fairly well, I mean, they are fairly obvious in the sense that, for example, in the French case, you have deliberations that we have in writing where the board is saying, okay, so there is a big legal risk in what we do. Yeah, okay. In the NL case, and this is where you have a personal data element. If I can recall the case properly, but they asked to the customer the permission to give their personal data, but they did it in a different ways for their subsidiary than for others. Yes. So come on, but we will not be in this easy setting when we are on the other cases.
Yes, it's true. You have to look. They were rather yeah. It was a bit of an abuse of the way they wrote the letters to the customers. Exactly.
No, yeah, for sure.
Yeah. So I'm afraid we've run out of time. It's always amazing how quickly the time goes by when you can discuss European case law on a sunny Friday afternoon when everybody's about to leave to go on a long weekend holiday. It's Pentecost. I think for many of us, we have a free day on Monday. And if we, for those of us living in, or those of you living in the UK, of course, Jubilee celebrations. So it's been great to have you all on board today. And my special thanks to Adrien, who's given up his time to bring us up to date on two complex cases and to give his opinion of what is important coming up. And it's always great to have the FSR supporting the platform, and to my colleague Max Munchmeyer, who helps in many ways, and he will be producing a summary. So for those of you who want to look back to what was spoken about, you can find the recording. There's a link already given, and we'll have the short summary for you up on our website. Usually within about a week or so, it should be there. So,
and thanks to you, Leigh. I think you made the hard part. Okay. All these regulatory cases.
Yeah. Anyway, thank you all for participating today.